State of Michigan versus Jermaine Jones. Mr. Reagan has the bond.
As the bond judge, we just ask the bond be continued at this time.
All right, Mr. Ragnan has the bond.
Yeah, and we're going to ask that the bond be changed to a remand. This is an armed robbery. There's 20 counts of felonies and crimes here that this defendant is allegedly involved in and allegedly committed. The complainant initially invited a friend of his, co-defendant Snow, over to a get-together. He came over with Mr. Jones, who the complainant also knows, and also another co-defendant, Mr. Shorter. They had masks on. They said they just came from a masquerade party. But when they got there, Mr. Jones pulled a rifle out and said, "Give me all your items that you have." And with that, the defendant was robbed of a number of items: Cartier glasses, cash, a lot of cash, chain, watch, a Rolex watch, shoes, wallet, and a number of items, okay? And with that, they left in this defendant's gray Ford Escape, I think it was, or Explorer. Now, all that's on video. They see them park the car, they see him go into the residence, they see him come out of the residence and get back in the vehicle. The victim knows who Mr. Snow is, so he starts showing the police on Instagram pictures, not only of the Mr. Snow, but ultimately shows them of Mr. Jones and also of Mr. Shorter. Mr. Jones, at some point on, is seen wearing the Cartier glasses that they were stolen from. He's also seen, which is not in the report, but I have seen one picture, and I haven't seen anything else, of him flashing on Instagram all this cash that were stolen, okay? So, Your Honor, it's a very serious matter. I mean, they're able to find out that the vehicle was owned, and they were able to go to the address. They were able to see the defendant pull up in the same gray colored Ford Explorer. They were able to, then they tried to extort the victim, Your Honor, by saying, if one of the co-defendants did, if you give us $5,000, we're going to return your items to them. And even when the victim was on Instagram showing the police the different Instagram histories of this defendant and also of Mr. Snow sends them a text message saying, "Get off Instagram." So they had his phone number as well. So there's a lot of evidence, Your Honor. This is a very serious matter. Communication by Mr. Jones at one point stating, "You might as well just kill him." Okay, that was his statement. Now, I want to talk about this man's history, Your Honor. He's got extensive convictions. Back on 9/8/13, he pled to felony assault with intent, less than murder, pled guilty, felony assault with intent, great bodily harm, less than murder, a firearm. 1/26/21, he was bound over for felony weapons firearm, 2 charges, CCW, reckless use of firearm. 5/5/21, he was bound over in 6th Circuit again on 5/5 for police fleeing and eluding. He was on probation at 39th District Court, a warrant for fleeing, 4th degree. And he had a warrant out for his arrest for probation violation for failure to appear. So, Your Honor, there's just a lot of evidence, I think. I think it's just a terrible crime, and I think pursuant to MCL 6.106, which provides for a remand for armed robbery, I believe that this defendant should be remanded, Your Honor. Thank you.
All right. Anything else, Mr. Reagan?
Absolutely, Judge. And I have to always be respectful to Mr. Ragnar because I have much respect for him. Judge, I just think that the whole purpose for a bond redetermination, and they say it at arraignment because the people made an argument at arraignment and the magistrate set this bond. That's the procedure we have in place. And the magistrate tells the defendant, you have a right now to a redetermination hearing, which we put in place so that you can have your bond relooked at. If the people want to file a motion to change bond, they have every right to do that. But that's not what this hearing was put in place for them to get 2 and 3 and 4 bites at the apple. That's not what it's for. I respectfully asked for bond to be continued, didn't want the hearing because it's the defendant's hearing to have or not to have. And I just respectfully asked that the magistrate set the bond after they heard the arguments of the people at arraignment, Your Honor, and the magistrate set the bond 100,000, 10% with the GPS tether, and that's what the bond was set at. And we just had asked for it to be continued and did not want the hearing that was put in place for the defendant to have in this situation, not for the people to get 2 and 3 bites at the apple for, Judge.
Well, call it what you want. Stop, Mr. Ragland. Whether it's a redetermination hearing or emergency bond hearing, I'm hearing this case de novo. I'm hearing the information that was presented to me, and I'm reviewing the file as it is set. And I don't have the transcript of the arraignment, but I can only go by what I see. And what I see, there's enough information here where I would have denied bond. As a matter of fact, I am going to deny bond. The defendant is remanded. Mr. Jones, I'm gonna give you a chance to talk with your attorney in private. So I know you have your hand up, and I don't want you to say anything that can incriminate you. So when you talk to the attorney, he's gonna let me know what you have to say, and we'll just do it that way because I don't want you to say anything that might get you in trouble. And I'm gonna give you a chance to go over what if I'm missing something, let me know, Mr. Reagan. But there is not only a lot of evidence presented here, which I don't make a determination of innocent or guilt, but I've got IDs, I've got contraband in the possession of the defendants. I've got a person who was arrested with a weapon, who was prohibited from having a weapon. I have a person who was previously convicted of a severe assault with a dangerous weapon that was originally charged assault with intent to murder. I have somebody who has indicated that he would potentially kill somebody during a robbery. Now, if I'm missing something, and understanding that I'm not the trier of fact, and these are allegations, this is, I don't understand why this bond was where it was, but now that I'm reviewing it, this is my decision. But Mr. Reagan, I know Mr. Jones has his hand up, and maybe I missed something that led to this. I'm gonna let you guys talk, and then we'll continue.
Yes, sir.
Thank you, Your Honor.
All right, Mr. Reagan, is there anything further?
Judge, I just wanted to point out, and Mr. Jones to point out, he hasn't been convicted of anything since 2013. And, he has some pending cases, as Mr. Ragnar did state, but he hadn't had any convictions since 2013. These are still allegations. And I think based on, Judge, and I still make my objection. I think that, when a person files a motion and they dismiss their own motion, and forced to have to argue their motion, it just gets dismissed. And I think that's what these redetermination hearings are about. But we're here, Judge, and my thing is, I just asked the court again respectfully to continue the bond as it was said by the magistrate at arraignment, Your Honor, after they heard the argument of the prosecutor, Judge. And Judge, I apologize. One of the co-defendants got a personal bond on this as well. Defendant number 3. I believe.
Your Honor, I don't think it matters what anybody got on a bond other than this defendant, and his history alone and the facts against him, I think, necessitate a remand.
And the other defendant hasn't been arraigned. Mr. Snow hasn't been arraigned yet, Judge.
I really don't know what I'm missing here. I'm denying bond. That concludes this hearing.
Thank you,
Mr. Jones, your next date is?
Your Honor, I haven't had a felony or a conviction of anything in over 10, 11 years. This case is something is crazy. I don't know how am I getting described a lot of guys with ski masks on. That's not me. listen, I've been working with the community. My auntie owns a church I've been working at. I have kids now. I've been working. I haven't even done anything like this in a long time, Your Honor.
Mr. Jones, I am not the trier of fact. In a couple of days, you're going to have another judge and you're going to have an attorney assigned to this case. If there's something I'm missing, if there are arguments to be made, I would strongly suggest that, you let your one second, sir, let me finish. I'm going to strongly suggest that you give, I'm sorry, 1 second. So as I was saying, Mr. Jones, your first date is going to be a probable cause conference before Judge Giles. That's going to be on June 24th at 8:30. Sir, by that time, you'll be assigned an attorney to follow this case all the way through, and you're going to have a chance to make every argument that you need to make. These are allegations. I'm not saying that you're guilty or innocent. All I'm just doing is taking the information that I have and deciding if there's a dangerous situation or a flight risk. And I don't believe there's a flight risk. And I do believe that there is a highly, highly dangerous situation involving the complainant as well as the community at large. So this is why I'm denying bond based on the statute. You have your hand up, sir. I got to remind you again that you have the right to remain silent, and anything that you say involving the case is going to be used against you. Yes, sir.
Okay, listen, I'm not a danger to anybody. I haven't did anything crazy. Like I said, I haven't been convicted of any felony or had anything out of crazy happen in over 10 years, Your Honor. I'm a family man as of today. I work, I do everything I'm supposed to do as right, Your Honor, right now. And I need to get so I can get my attorney and get my everything taken care of so I can fight this case, Your Honor, so I can defend myself and my rights, Your Honor. I can't do that inside here. Like you say, I'm not a fighter, you don't think so, so I'm gonna come to court. I'm not a danger to the community because I didn't hurt I don't hurt people. I don't do anything and even in my case in 2013, I never hurt anyone. I never hurt anyone. They gave me that charge, but I never hurt anyone, Your Honor, in my whole life.
All right, that concludes the
hearing. Thank you very much, Your Honor.
Remember what I
told you? You can get him out of here. I'm done. What's that?
I was just saying, I was just telling Ms. Jones, remember what I told you at your next hearing. Okay. Thank you, Judge.